Mr. Jones, I'm going to tell you one. Mr. Jones, I'm going to tell you.
I'm not allowed to object. I'm my own counsel now. I'm allowed to object, ain't I? It's only 3 years.
When I'm talking, you do not talk over me. Do you understand that? Because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years. I don't need
Mr. Jones, I don't care what you want with regard to that. I'm following procedure, and this is what we're going to do.
All right, everyone, today we're diving into the curious case of a self-proclaimed sovereign citizen who seems to treat the law as nothing more than a mere suggestion. This character exudes an unsettling arrogance that not only irritates but also raises eyebrows across the board. Currently, he's adding insult to injury by serving an extra 3 years for assaulting an officer, on top of the 4 years already doled out for armed robbery. His mindset and actions clearly stray from the norm, leaving us to wonder if it's a case of deep-rooted mental instability or just a blatant disregard for societal rules. Let's take a closer look at the layers of this heated courtroom drama. Could it be that his defiant behavior is fueled by a profound misunderstanding of the law, or are we witnessing the actions of someone battling serious psychological challenges? As we dissect the details of his controversial case, consider the broader implications for our justice system and personal accountability. What do you think? Is his conduct a reckless misinterpretation of freedom, or does it point to deeper issues at play? Let's unravel this perplexing scenario together and see where the conversation leads.
Your Honor, my client has indicated to me that he might want to represent himself in this matter. I just wanted to bring it to the court's attention to have the court address that issue.
All right, Mr. Jones, why don't you tell me what's going on?
I just want to represent myself. I feel like nobody's going to fight for me like I'm going to fight for myself. I've been through voir dire, I've been through jury trials, I've done all this before.
Did you go to law school?
No, I did not, sir.
So do you know all of the rules of evidence and the rules of criminal procedure?
I don't think I really need it with this case.
Yes, you do. You absolutely need them, because every time something happens, Mr. Arnold here has been a practicing trial attorney with the prosecutor's office in Hamilton County and Warren County for how long, Mr. Arnold?
Well, if you add in military time, almost 46 years.
46 years. He's a skilled trial attorney. He knows the rules of evidence and he knows the rules of procedure. You can roll your eyes at me all you want.
I don't really care about none of that.
But here's the problem. I'm required by my canons that I hold you to the same standard that I hold Mr. Arnold, even though you have no formal training or education in the law.
All right.
I'm sorry?
It will be all right.
It won't be all right. I'm telling you,
you won't. Man, it ain't no time, bro. I got 10 in, 4 left to do. I do not care at all, even a little bit. It's 3 years. It's cut and dry. What happened happened. I didn't start this. Let the jury decide. I don't care about none of that, bro. None of the stuff you talking about right now make any sense to me. Do I care about it at all, even a little bit, man? It's 3 extra years max.
So what are you telling me?
I'm telling you, I can represent myself. I can handle it. It's not that serious.
Ms. Martin is a skilled trial attorney.
That's cool. I might be a skilled trial attorney too. Sometimes you got to try stuff in life, and you never know how good you might be at that.
You ever picked a jury before?
I have. I've been through mass of those. I've been through at least 7 different ones of those. Some of them didn't go all the way through. People got sick and stuff like that. Had to do it all over again.
You realize that if you do this, you cannot use ineffective assistance of counsel as a grounds for an appeal. It's not a basis for an appeal. You'll be representing yourself. You'll be held to the exact same standards that I hold Mr. Arnold to, and it would be a huge mistake.
All right.
I'm sorry. Cool. It's not cool. It's you're making a huge mistake.
I mean, I made a whole bunch of them. I'm sitting in prison right now for something I ain't do, so I make a lot of mistakes. You can't live life with regret, man. You gotta do what you gotta do.
It appears that this guy is prepared to accept an extra 3 years behind bars, even when there might be ways to trim that time down, because that's just his way of handling things. Already locked up for aggravated robbery, if his jury trial adds another 3-year stint, he's staring down a total of 13 years in prison. One can't help but wonder what his strategy is. He keeps touting a 3-year deal, while the math clearly spells out a much longer sentence. It's almost as if he's deliberately setting himself up to rack up time, almost treating incarceration like a twisted badge of honor. Given his behavior, there's little doubt the jury is going to find him guilty, sealing his fate even further. What do you think? Is this a calculated ploy or simply a case of self-sabotage? Let's dig deeper into this perplexing scenario and explore all the angles of his baffling approach.
Well, I'm inclined to decline that request. We are here on the day of jury trial. The jury is waiting for me to bring them down. I'm inclined to allow Ms. Martin to proceed representing you.
I don't want Ms. Martin representing me. I want to represent myself. I don't need somebody that's going to lay down and work with the prosecution. I'm going to do what
Ms.
I
Martin
gotta do.
does not.
I mean, that's cool. Your opinion is irrelevant in this matter. Your opinion is not helping her none. You work with the prosecution. You ain't here for me.
You are incorrect. I do not work with the prosecution. I do not work with the defense counsel. Actually, one of my functions here is to make sure that your constitutional rights are protected, which is what I'm doing right now.
Tested.
I'm sorry?
That will be tested. We will see about that.
The other problem is obviously you have a right to remain silent. With you asking questions and you're making a huge mistake.
It's added to the list. It's a whole bunch of them. It's a long list.
Has anyone threatened you in any way or promised you anything in order to get you to waive your right to counsel?
No. Just want to represent myself. I can't go any worse than it might be about to go. It's only 3 years, man. It's only 3 years. I got that.
And as long as you understand that in asking questions and picking the jury and everything that you do, here's the other problem. Here's the other problem. Is he in shackles?
Yes.
Okay, there's the other problem. Because you are in custody, you have shackles on. You want the jury to see you in shackles?
And that's grounds for an appeal by itself. I realize that part. You're not supposed to let the jury see me in shackles, so I mean that's kind of like a tipsy-turvy type of thing right there. I know a little bit more than most. Ain't all the way simple, close to it, but a little bit more than most.
Your Honor, if you're going to entertain this, I think you need a written waiver, A, and a much more detailed, the 12th District, and I can't remember the name of the case, a few years ago, came out with a much more detailed.
All right, we'll go through it. Hang on. All right, Mr. Jones, you've been handed a waiver of right to counsel. You understand that you have the absolute constitutional right to be represented by an attorney. Do you understand that?
Yes, sir.
You understand that you are not being charged for Ms. Martin's services, that you have the right to have an attorney appointed to you free of charge. Do you understand that?
Yes, sir.
And you understand the charge against you is a felony of the 3rd degree assault because of your status, the status of the alleged victim, and the location of the incident being in the Department of Corrections, that the maximum penalty is 36 months in prison.
Correct.
All right. Are you aware of any possible defenses to this charge or this allegation?
Meaning what?
I'm just asking the question.
Are
you aware of any? Are you aware of any?
I don't understand the question you're asking, sir.
Well, you're going to represent yourself and put on a defense, I assume,
Correct.
at least by way of cross-examining the witnesses presented by the state.
Right.
You understand that?
Yes, sir.
All right. You understand that there may be possible defenses that you could raise in your cross-examination of the state's witnesses or in presentation of witnesses on your own behalf. You understand that?
Like impeaching a witness?
Sir, I'm not going to explain every single thing to you. That's why I'm trying to encourage you to go with counsel here. Do you understand?
Yes, sir.
All right.
This individual clearly fails to grasp the true cost of his actions. I can almost imagine him nonchalantly remarking, "It's only 10 years, bro, if you were facing a decade behind bars." But let's be honest, when you only have one life to live, every single year counts, and 3 years in prison is far from trivial. It's not just a number. It's a significant chunk of your life where time slips away and memories fade. What's even more disconcerting is his casual dismissal of that reality. Here we have a guy who seems completely unfazed by the consequences, acting as though spending years away from the world is no big deal. It's unsettling to think that someone could be so indifferent about the law, especially when we see people like him brazenly walking into gas stations with a weapon in hand, threatening everyone around. What could possibly justify such behavior? Is he grappling with deep-seated mental health issues, or is it just a blatant disregard for reality? In a world where every moment behind bars takes away from a lifetime of experiences, his attitude is not only baffling, it's downright dangerous. I'd love to hear your thoughts. Is his approach a sign of underlying psychological struggles, or is he simply oblivious to the weight of his choices? Let's dive back into the discussion and unpack this perplexing situation further.
There may be possible mitigating circumstances. Do you understand that?
Huh? No, nope, I don't.
You don't know what mitigating circumstances are? Again, that's another reason why you need to have
3 years, man. That's
I'm sorry?
3 years. That's nothing.
Let me tell you something. If when I'm talking, you do not talk over me. Do you understand that?
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years.
Well, you're the one that's elected to go with the jury trial, so you keep on saying it's only 3 years. That's fine. All right.
They try to give me 2 of it anyways. Might as well go to trial.
Okay. You understand, and I've told you several times now, if you represent, you will be detrimental. It will be detrimental to your case. You understand that?
I don't know if I believe that. That's your opinion.
It is my opinion, and I'm strongly advising you against it. But you understand that in my opinion, if you represent yourself, it will be detrimental to your case.
Everybody's entitled to their opinion.
Okay. But you understand what I'm telling you?
Yes, sir.
All right. And you understand that if you represent yourself, you're going to be held to the same standards as any other defense attorney and the same standards as I'm going to hold Mr. Arnold. Do you understand that?
Yes, sir.
Have you ever represented yourself before in any criminal prosecution?
No, sir.
And you wish to go forward today without the assistance of an attorney?
Oh, can I get a few minutes? I use the bathroom anyways.
A few minutes for what?
To use the bathroom, think about it, make sure this is what I want to do.
There might be some circumstances that could lessen the overall impact of your actions, but you seem to miss the point entirely about what mitigating factors really mean. Frankly, 3 years is hardly a drop in the bucket when you truly understand the weight of your choices. Now let me be absolutely clear. You are expected to behave appropriately in my courtroom and before this jury. Any sign of misconduct will lead to consequences that will not only be swift, but also severe. You've chosen a jury trial, and yet you keep insisting that 3 years is just a minor inconvenience. Despite your repeated claims, the reality is far graver. I've warned you several times, if you decide to represent yourself, it will only work against you, negatively impacting your case. While everyone is entitled to their own opinion, believe me when I say that self-representation in a matter like this is a dangerous gamble. Understand that if you insist on handling your own defense, you'll be held to the same rigorous standards as any seasoned defense attorney, and I will enforce those standards strictly. Mr. Arnold, I need you to grasp the seriousness of your situation. Have you ever managed a criminal prosecution on your own before? No. Then consider carefully before you proceed without legal counsel. Now, if you truly wish to move forward without an attorney, I am willing to give you a few minutes to reconsider. Take a moment, perhaps even a short break, to use the restroom and reflect on whether this is really the path you want to take. Use this time wisely to ensure you understand that every decision you make here has far-reaching consequences.
Can I say something real quick, Your Honor? I didn't get that opportunity to use the bathroom. Your officer wouldn't allow me to come out the cuffs. I don't know how I'm supposed to. I don't want to be rude or crude. Like, I know I got off to a bad start with you, sir, and that's not what my intentions were. I'm just kind of obnoxious. I'm sorry.
Yeah, I'm not in charge of security here, Mr. Jones. The deputies and the transport officers are in charge of your security of this.
How am I supposed to use the bathroom in cuffs? How am I supposed to be able to wipe myself in cuffs?
All right.
Your officer refused to move the cuffs when I was locked in the cell. I'm just trying to use the bathroom. I need to use the bathroom before we get started, sir.
Rhodes?
Yes, sir.
What's the issue with him?
I was never asked to remove the cuffs.
She was, man. You know I had to use the bathroom. I don't know what else I'm supposed to say. I need the cuffs.
All right, let's get through this, and we'll talk about your bathroom after that. All right. I advise you that you're charged with an assault of a corrections officer as an inmate at the correctional facility. Maximum penalty, as we've said, is 36 months in prison. After closing arguments, I will give the jury the instructions of law. Now, the issues that present themselves with regard to you representing yourself, obviously, is a logistics issue. Since you are incarcerated, the shackles on your legs will remain. The court is going to make a finding, and again, if you want to have a hearing on this, Mr. Arnold.
Your Honor, I just asked the court to take note that he's previously been convicted of assault on a corrections officer and is an inmate incarcerated for offenses of violence.
So I'm gonna make a finding that you pose a security risk to this courtroom, so the shackles on your legs are gonna remain there. Now, I'm going to accommodate you in that both the state and you will do your opening, your voir dire, your opening, the questioning of witnesses, and your closing arguments from counsel table. Now, you can stand up at that table without your legs being seen, because for the record, there's a skirt, or the bench itself in front of you hides your feet. No one can see your legs. You understand that?
Yes, sir.
All right. So I've already told you that in the court's opinion, representing yourself is probably going to hurt your case, right? You understand, and I've said to you already that the state of Ohio is represented by a competent, experienced trial attorney, and that you will be held to the same standard as Mr. Arnold. You understand that?
Yes, sir.
All right. The rules of evidence and rules of procedure, even if you don't know them, will apply to you. Do you understand that?
Yes, sir.
I cannot assist you at all during the course of the trial.
Yes, sir.
You want to again understand that this is not a license for you to abuse the dignity of this court.
Yes, sir.
There will be no appeal for ineffective assistance of counsel.
Okay. Yes, sir.
Again, how old are you?
38.
How far did you go in school?
Dropped out.
So are you able to read and write?
This whole act feels too scripted, like he pulled it straight out of a rehearsed play. He was dead set on representing himself, only to suddenly claim he needs time to reconsider. Honestly, it comes off more as a stalling tactic than genuine reflection. Think about it. This is the same guy who robbed a gas station and ended up with a 10-year sentence that he dismisses an extra 3 years as if it were nothing. What's really going on in his head? Is he merely buying time, or is he actually rethinking his strategy? If I were the judge, I'd suspect he's trying to engineer a way out, perhaps even plotting to bolt from the courthouse. The red flags are waving high. His sudden flip in attitude raises serious doubts about his sincerity. Is he playing for time, or is there a hint of real concern behind his change of heart? Let's dive back in and unpack this tangled situation together.
Are you on any type of medications or drugs?
No, sir.
Do you have any prior experience in representing yourself?
Not representing myself. I've always had good dialogue with my attorneys.
Okay. Do you have any prior experience, your prior experience in the legal system?
Just being charged with stuff.
Okay. You don't have any formal training in the law?
No, sir.
And you have no mental deficiency or conditions that would interfere with you understanding what's going on here today?
Not that I'm aware of. Debatable,
though. Now tell me once again, is it your intentions, is it your desire that you want to proceed in this trial representing yourself?
I'm pretty sure.
No, you got to be certain.
I mean,
Why don't we do this, Mr. Jones? Let's allow Ms. Martin to represent you, and if something happens and you can change your mind later. It's easier to go that way than to go the other way. You can't have it both ways. What's that?
I use the bathroom, please. I really gotta go, sir. I just need to use the bathroom. I'd be a lot more focused and stuff. I really gotta use the bathroom.
All right, Rhodes, take him to the bathroom. I'm not going to go over this with you again.
That's
You have this
fine.
one last opportunity.
I understand, sir.
All right. Take him, let's go off the record. All right, we are back on the record in the state of Ohio versus Aaron Jones. Mr. Jones, you've had your second trip to the bathroom now. I take it everything went better?
Yes, sir.
All right, now, you have in front of you a form called waiver of counsel. I've gone over with you all of the elements of granting that waiver. Do you still wish to proceed as your own counsel?
I need to get some counsel. I need real counsel. I talked to my family. They was talking about hiring a lawyer. I thought it was a little more cut and dry. I had a little more confidence in Miss Martin in that. And just at this point in time, I'd rather just wait on my family to get a lawyer for me.
But that's not going to happen. This case is proceeding to trial today.
Well, I'll represent myself then.
You want Mrs. Martin
No,
to...
I don't want her near me, around me, or nothing. She can.
All right, sign the form in front of you.
What's the date?
Today's the 18th. All right, Ms. Martin, you'll stay behind Mr. Jones as standby counsel. Mr. Jones, you have, that's your signature, sir?
Yes, sir.
And you read this document?
No, not really. Why is Miss Martin here?
Because I'm making her a standby counsel in case there's an issue. She'll be in the back of the courtroom.
I don't need no
Mr.
help.
Jones, I don't care what you want with regard to that. I'm following procedure, and this is what we're going to do. Read the form, please.
The whole reason,
Mr. Jones, read.
Of representing myself was because I didn't trust the lady. That was the
Okay,
whole purpose of
she's
that.
not.
But she's still here and attached to my case. That's the
She's
whole
removing
purpose of
herself.
removing her was for that. Was for me to be able to represent myself.
You will be. Sign the form.
This
Read
form
it.
was already signed. You
All
already
right,
seen my
read.
signature. You already
I'm
asked
sorry, I
me my
misspoke.
signature. You see my signature was on that shit. You already seen it was there. What are you talking about?
I won't lie. I fully expected him to flat out refuse even the basics of reading or writing. This guy's behavior is nothing short of baffling, like he's determined to play the fool in front of everyone. Yet here we are, left wondering, do any of you feel even a hint of sympathy for him? Maybe a rough childhood warped his sense of judgment, but that's no free pass to act out in a courtroom. Regardless of his past, there's simply no excuse for behaving like this when you're facing a judge. He's not your average sovereign citizen either. He goes well beyond that, exhibiting a rudeness that's among the worst we've seen on this channel. Standing before a judge and confronting a 3-year sentence should be a wake-up call, not a game to toy with. And let's be honest, if he picks up another charge in prison, he might just be looking at an extra 5 years on top of everything. This situation feels like a tangled mess of self-sabotage and misplaced bravado. Is he genuinely reconsidering his approach, or is he simply stalling, trying to buy time with empty promises? I can't help but wonder if there's a deeper story behind this reckless behavior, or if he's just determined to dig his own grave. What do you think? Should we cut him some slack, or is this guy just too far gone? Let's dive back in and unpack this perplexing case together.
Mr. Jones, read the form. You
Bro,
said you
I already
didn't read
signed
it.
it, man. It's cool. Go ahead.
Read the form. Are you able to read and write?
Sometimes. Depends on how many pictures are on.
You done?
I ain't read it. I
get the
already
form.
signed it. We already went over it. It's cool.
All right, the court will make a finding then, sir, that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and the court will accept that. Ms. Martin will stay in the courtroom as standby counsel. Other than that, are we ready to...
Ms. Martin is standing by counsel.
Mr. Jones, I'm going to tell you one... Mr. Jones, I'm going to tell you
I'm not allowed to object. I'm my own counsel now. I'm allowed objecting, ain't I?
Then you say the word objection.
I did. I said I object.
What are you objecting to?
I'm objecting to Ms. Martin standing by as counsel. I'm representing myself. I'm objecting to having her here. I don't trust her. So that's the whole reason of me releasing her was to represent myself because I didn't feel confident with her abilities, nor did I feel confident enough with her not working with the prosecution in order to help lay down and obtain a conviction. My removing of her wasn't based on...
Stop. Your objection is overruled. Ms. Martin will stay in the courtroom as acting counsel. Standby counsel, sorry. All right, are we ready to bring the jury down?
Yes, Your Honor.
All right, bring them down.
I seriously can't wrap my head around how this guy can casually jabber to a judge like he's completely indifferent, like he doesn't give a damn. It's almost comical. Here's a scrawny little white guy putting on a tough act, as if his swagger would somehow intimidate the courtroom. Spoiler alert, neither the judge nor the rest of us are buying his act. Honestly, it seems like he might already have a boyfriend waiting for him behind bars, which could explain why he's so unbothered by the prospect of another 3 years. It's as if he's made prison a part of his identity, treating each additional sentence like just another day on the schedule. Whether he's delusional or completely detached from reality, his nonchalance comes off as a pathetic attempt at bravado. So what's your take? Do you think his laid-back attitude is a cunning ruse, or is he just too far out of touch with reality to care? Let's dive back in and unpack this wild case together. Perhaps he's already plotting his next move, or maybe he's just counting down the days until he can reunite with his husband in prison. A truly unconventional love story, if you ask me. Either way, his case is one of the most unforgettable and bizarre we've come across. What do you think? Is he a calculated risk-taker, or just another example of overconfidence gone awry? Let me know your thoughts in the comments below. And if you enjoyed this breakdown, don't forget to like and subscribe for more intriguing stories. Thanks for watching, and until next time, stay sharp.